the barbecue. Thank you. Thank you.
Governing possession and operation of firearms. You've heard already this morning, and you'll hear this afternoon from people who are. My field is constitutional law. I teach other courses related to U.S. constitutional law as well, but for present purposes, my focus is on the federal constitutional parameters that limit the ability of the federal, state, and local legislators and administrators to regulate guns. And things have changed drastically since I spoke at last week's symposium in North Charleston. For those of us operating here in the Fourth Circuit, just yesterday, in a case arising out of Maryland, Chief Judge Traxler of Greenville, writing for a two-judge plurality on a three-judge panel, struck down a federal district court judgment out of Maryland which had upheld Maryland's so-called assault weapons ban and restriction on certain high magazine or large magazine weapons. That creates a split in the circuits and a possibility of a third Supreme Court, United States Supreme Court decision on the Second Amendment in the very near future. So I suspect this time next year we may well be talking about a pending case before the United States Supreme Court, once again testing the limits of constitutionally permissible restrictions on firearms ownership. The opinion out of the Fourth Circuit is 90 pages long. I got it last night at 5 p.m. I was hoping to digest it for you prior to today's session, but yesterday was my 2-year-old's birthday, and then I spent more time in traffic this morning than I planned. So what I'm going to do is digest the Fourth Amendment decision in the coming week or so, and then email my blurb to Steve, who will be able to distribute it to you. But we'll trace today the constitutional parameters established by the Supreme Court's two recent Second Amendment decisions, Heller versus the District of Columbia, or I should say actually District of Columbia versus Heller from 2008, the first Supreme Court case to enforce a Second Amendment claim, and the first Supreme Court case to recognize a Second Amendment right unrelated to service in the militia or possession of weapons suitable for use in the lawfully established militia. And then we'll talk a great deal also about McDonald versus City of Chicago, the 2010 case in which the Supreme Court applied the Second Amendment right against the states and local government for the first time. Heller was a 5-4 decision written by Justice Scalia. Justice Scalia relied heavily on his signature methodologies of plain meaning textualism and original public understanding of constitutional text to strike down the District of Columbia's ban on handguns and the D.C. requirement that permissible weapons kept in the home be kept either disassembled or fitted with a trigger lock. 4 dissenters in separate opinions by Justices Breyer and Stevens maintained what up until that time had been the predominant view among federal judges, that the Second Amendment concerned a militia-linked right rather than a right to weapons possession for private purposes such as self-defense of the person or the home, gun collecting, hunting, etc. Heller departed from precedent, but it was very old precedent. So there were 4 Supreme Court Second Amendment decisions prior to Heller. United States versus Cruikshank from 1876, Presser versus Illinois from 1886, and Miller versus Texas from 1894, all involving essentially the same issue, whether any Bill of Rights provisions were applicable against the states. The Supreme Court in those three late 19th century cases, not surprisingly, held that the Second Amendment right did not apply against the states, but this was at a time before the Supreme Court had applied any Bill of Rights provisions to limit state action. In the 19th century, it was widely assumed that the Bill of Rights bound only the federal government, that it did not bind state government at all. So these three 19th century Supreme Court decisions were unexceptional. You wouldn't have expected to prevail on a First Amendment claim against the states or a Fourth or Fifth Amendment claim against the states in the 19th century, because the orthodox opinion was the Bill of Rights was intended only to protect against federal abuses. United States versus Miller from 1939, there's two Miller cases. There's Miller versus Texas in 1894, and United States versus Miller from 1939 did reach the substantive scope of the Second Amendment. The issue in the second Miller case, United States versus Miller in 1939, was the constitutionality of the National Firearms Act of 1934. A federal district court had struck down application of the National Firearms Act in the case of the criminal prosecution of two Depression-era gangsters who transported a sawed-off shotgun across state lines. According to the federal district court, that was Second Amendment protected activity. The Supreme Court, in an opinion by Justice McReynolds, disagreed. And Justice McReynolds, oh, I think I turned off my mic. No, I didn't. Oh, we must have just momentarily lost amplification. By the way, how's the volume in the back? We just good sound level, excellent. If I get too loud or too quiet, please let me know. So back to the Miller case of 1939 and the somewhat cryptic opinion of Justice McReynolds for the court. He wrote this direct quote: "Certainly it is not within judicial notice that this weapon, the sawed-off shotgun, is any part of the ordinary military equipment or that its use could contribute to the common defense." So certainly Justice McReynolds seems to be thinking of a militia service-related right, and by 1939, the militia system was very different from the militia system of the framing era. The Dick Act of 1910 created the modern National Guard system, and basically state militia organizations all came under the control of the federal government. Well, not necessarily direct control, but states accepted federal spending with strings attached and agreed to allow their previously independent militia units to become part of the United States National Guard, at least when called into federal service, in return for federal funding of state armories, federal provision of weapons for the state National Guard units, etc. But in any case, this militia of the 1930s and the militia of today, at least the active militia, as opposed to the reserve militia, and that's a distinction made in the Dick Act, is a select militia, if you will, an all-volunteer militia consisting of a small segment of the population, unlike the militia of the framing era, which was essentially universal and compulsory, at least for, according to the Federal Militia Act of 1792, white males between 18 and 45. So in 1939, Justice McReynolds looks at the text of the Second Amendment, looks at the National Firearms Act of 1934, and says these provisions essentially inhabit different universes, or at least insofar as the National Firearms Act was applied to prosecute gangsters for carrying a sawed-off shotgun because that sawed-off shotgun was not a weapon suitable for military purposes. The carrying of that weapon was not, if you will, a Second Amendment event. Now, you could read Miller two ways. You could say the Second Amendment right attaches only to persons actually in militia service, actually in the National Guard, or you could read it to attach to any weapon which was of a type that might be useful for militia service purposes. But between 1939 and 2001, every United States Court of Appeals read the Second Amendment as interpreted in Miller in, if you will, an unfriendly way towards gun rights. Every decision of the United States Courts of Appeals in all of the circuits up until 2001 denied Second Amendment relief to claimants on the grounds that, as construed in Miller, the Second Amendment concerned either the rights of persons actually doing militia service or the right of persons who were either in the militia or eligible for militia service to have the sort of weapon that was useful in National Guard service for purposes of training and readiness. But by the 1980s, there was a movement afoot to create a different interpretation of the Second Amendment, and something that today is sometimes called the standard model was hashed out in the 1980s and 1990s in a series of law review articles by advocates and by academics who took a much friendlier view of the constitutional protections afforded by the Second Amendment for gun ownership and argued that the Miller court had either misinterpreted the Second Amendment or that Miller reflected only the very narrow application of the Second Amendment in that particular case, and that the original understanding of the Second Amendment embraced a much broader right to have weapons for purposes of self-defense and hunting and collecting, etc. Yeah. I'm having trouble hearing you because I just got out of my rather noisy Jeep, so. So that's a great question, and for those of you who didn't hear, the issue is what about a 10th Amendment argument? And I think you actually embedded two your very powerful insights in your question. So you pointed out that most of the states did not join the Union until long after the Bill of Rights was ratified, suggesting that why talk about the original meaning of the Second Amendment in 1789 when it was proposed, or 1791 when it was ratified, if you're concerned with, say, gun ownership in Alaska, which Alaska became a state in, what, 1958. Interesting point. That's one of the odd things about originalism, and not just originalism, an odd thing about constitutional litigation, constitutional law in the United States more generally. The assumption is that what makes sense for Rhode Island or Virginia or South Carolina, some state that joined the Union at its formation, and that you had in place a system of English common law and recognized the applicability of English statutes at least up until 1776, should apply also to Alaska, which was once a Russian dominion that didn't come under United States control until 1867, or or apply in New Mexico or Texas, which were under Spanish law? Great question. I don't have an answer to that one. I mean, it's just the way that the Supreme Court has always done business. The assumption is that talking about the original understanding of the Constitution in 1788 is an appropriate way to talk about constitutional limitations on the power of California, or constitutional limitations on the power of Alaska. You're right. Doesn't make sense. Well, what about the 10th Amendment? So the 10th Amendment preserves to the states and the people those powers not described, not granted to Congress or the federal government in the Constitution. At least in terms of litigation, the Supreme Court is not currently listening to individual rights arguments based on the 10th Amendment. The 10th Amendment was largely dormant between the New Deal and the 1970s. From 1937 onwards, you couldn't get a 10th Amendment claim into court. Under a case called National League of Cities in 1976, I believe, there was a 9-year window in which states could, before National League of Cities was overturned in Garcia versus San Antonio Metropolitan Transit Authority in 1985, there was this decade-long window in which states could successfully argue that some federal regulation, when applied to the states as states, was unconstitutional because it violated 10th Amendment sovereignty. And the argument was, say, federal minimum wage laws shouldn't apply to state employees because the federal government shouldn't be able to tell the states directly what to do, i.e., pay your employees minimum wage. That argument disappeared in Garcia, but then in two interesting cases in the early 90s, New York versus the United States, the Supreme Court holds that Congress can't order the states to legislate. And then in Prince, a case involving gun ownership, and a case that Justice Thomas would have liked to see argued on Second Amendment grounds. Justice Scalia writes an opinion dealing with the Gun-Free School Zones Act, dealing with the Brady Bill, and holds that Congress cannot order state law enforcement officials to do background checks. So the Brady Bill's then rewritten, and as it stands today, the federal government conducts the background checks required by the Brady Act rather than the state. But to the extent that the 10th Amendment is litigated these days, it involves only three sorts of claims. Congress may not order the states to legislate. Congress may not commandeer state civil servants into enforcing federal policies, and Congress may not coerce the states. This is from the Sebelius case, the first Obamacare case, may not coerce the states into enforcing federal legislation or legislating by offering them a choice between financial inducement and a penalty that's so large that the states really no longer have any free will. So in that case, the coercion involved the prospect of withholding all Medicaid funds, not just the promised Medicaid expansion of funding, but funding for already existing Medicaid programs, unless the courts created a health care exchange. And the Supreme Court struck down that part of the Obamacare legislation, the Health Care Act, on 10th Amendment grounds. But anyway, the short answer that I should have given you is this. As an individual, you just don't have any 10th Amendment claims as far as the Supreme Court is concerned today. If you're a state, you can make a anti-commandeering claim. You can make a claim that the state was either impermissibly ordered or coerced to legislate. But as an individual, as things stand, even though the text says the people, not just the states, retain powers not described in the constitutional text, you're not going to have any luck with a 10th Amendment argument. But maybe a 10th Amendment argument would make more sense for those states that joined the Union long after this original understanding had formed and played itself out. But of course, the 10th Amendment is part of the Bill of Rights as well. So the 10th Amendment and the Second Amendment enter the Constitution on the same day in 1791 when Virginia becomes the ninth state, bringing up the 3/4 required to ratify the Bill of Rights. So, good argument, but I'm skeptical that it's a winner. At least insofar as contemporary Supreme Court practice is concerned. So, by the I'd say turn of the century, by the dawn of the new millennium, it looked like academic consensus had swung in favor of a broader reading of the Second Amendment. A lot of NRA prize money went to essay writers. Many libertarian think tanks funded academic chairs. George Mason Law School appointed several Second Amendment professors, about 9 professors at George Mason who specialize in the Second Amendment and take a very gun-friendly view of the Second Amendment. And there was sufficient authority for judges who were interested in writing an opinion suggesting that the Second Amendment was much broader, offered protections unrelated to militia service than those implicit in the Miller decision. So, not surprisingly, a split in the circuits emerges. In 2001, the Fifth Circuit, in a case out of Texas called Emerson, acknowledges that the Second Amendment protects a broad class of rights for gun owners unrelated to militia service. But Emerson doesn't go up to the Supreme Court for a couple of reasons. One is that Emerson himself got no relief. The district court and the Fifth Circuit accepted Texas' argument that Emerson, who was under a restraint order during divorce proceedings after threatening his ex-wife, the children, and police officers and social workers with certain death, merited having his Second Amendment rights restricted. And then there's the related problem of Emerson being an unsympathetic plaintiff. So gun rights organizations were looking for someone a lot more attractive than Emerson to be associated with the effort to reinterpret the Second Amendment or annul the existing interpretation of Miller. A sympathetic candidate emerged in the District of Columbia in the form of Special Police Officer Dick Heller, a United States Capitol Police officer who lived in a somewhat dangerous, but to be honest, now rapidly gentrifying, actually by now gentrified area of the District of Columbia, wished to protect himself at home, pointed to muggings of members of Congress, assaults even on elderly Supreme Court justices in the area of the Capitol in the Supreme Court, and was unable to get a license or a permit from the District of Columbia government to keep his service weapon at home in operational conditions. So D.C. required that permissible firearms and for the general public that would not be any handguns when kept in the home be disassembled, fitted with a trigger lock, or in a gun safe. So Heller's argument was, I live in a high crime neighborhood, I can't defend myself. Notice it has nothing to do with militia service. In a case called Parker, the District of Columbia Court of the United States Court of Appeals for the District of Columbia agrees with Heller and Parker and 4 others that their constitutional right to self-defense, that the Fifth Circuit had acknowledged in Emerson, but that the Supreme Court had not yet acknowledged under the Second Amendment, was violated by D.C.'s strict gun control regime. The case comes up to the Supreme Court under Heller's name because none of the other plaintiffs had actually applied for a license. So Heller was the only person who had standing to proceed. In fact, the D.C. Circuit had denied a relief to any of the other plaintiffs on the grounds that they lacked standing. They were just, in essence, members of the general public who disagreed with D.C. policy. Heller, on the other hand, had suffered a legally cognizable wrong. He wished to obtain a license and a permit in order to exercise his right to self-defense in the home. He couldn't do so. So with the Fifth Circuit and the D.C. Circuit recognizing a constitutional right to have weapons for self-defense embedded in the Second Amendment, the Heller case comes before the Supreme Court in 2008, and Heller is represented by a very interesting advocate, Alan Gura, not with a big law firm, not with a gun rights organization, not with a think tank, not a regular collaborator with the NRA, but a solo practitioner in Alexandria, Virginia, who, if I recall, principally focused on probate work, but a gun rights enthusiast who takes Heller's claim and takes it to heart. Gura ends up arguing McDonald, the case out of Chicago, the incorporation case as well, and Gura likes to push strong arguments. He's not the sort of litigant who strikes a compromise position in the hopes of appearing the most reasonable person in the room. He's someone who goes for total victory. So Gura argued that not only was the Second Amendment right a right that did not have to be linked to the militia, he argued that the Second Amendment right to have weapons for purposes of self-defense should trigger strict scrutiny, that in essence the right was absolute and subject to very limited regulatory restraint by government. And as oral argument played out in the Supreme Court, it became clear that there'd have to be some sort of coalition building in order for Heller to get relief, in order for Gura to win his case. So 4 justices, Breyer, Stevens, Ginsburg, and who am I missing? Goodness. In 2008, yes, Sotomayor expressed extreme skepticism, made clear that they viewed the Second Amendment as related exclusively to either a state right to maintain a militia or the right of members of the regulated militia to keep heavily regulated weapons for purposes of service in the lawfully established militia. Chief Justice Roberts expressed extreme skepticism about strict scrutiny, and indeed the whole tiered scrutiny operation. So for those of you who don't focus on constitutional issues, or may not be lawyers, or who may have been doing other things since law school, not generally constitution related, in the 1970s and 80s, there was a tendency among some judges and many constitutional law professors to describe the entire American constitutional universe in terms of this system of tiered scrutiny. The default norm was rational basis review. Most challenged laws and executive orders were subject only to rational basis review. Judges were quite deferential as long as the challenged executive order, regulation, or statute served a legitimate governmental purpose and chose means rationally related to that purpose, it would be upheld. Some types of laws and regulations triggered intermediate scrutiny, most famously classifications based on sex triggered a standard of review that required the government to demonstrate an important interest and means substantially related to that interest to pass muster. And then other classes of laws, those that involved race-based classifications under equal protection, or many that impacted a so-called fundamental right, whether that was the right to sexual privacy associated with Griswold and Roe versus Wade, or whether that was a First Amendment right made applicable to the states through the Due Process Clause of the 14th Amendment. The argument was that any government acts that impact exercise of these rights that the Supreme Court had labeled fundamental would trigger strict scrutiny. The thinking was strict scrutiny was, quote, strict in theory, fatal in fact. In other words, as soon as you heard a judge reading an opinion from the bench, and as soon as that judge started using the language of strict scrutiny, talking about a compelling governmental interest and means that had to be either narrowly tailored to that compelling governmental interest, necessary to serve that compelling governmental interest, or in the most demanding version of all, the least restrictive means possible to attain that compelling governmental purpose, you knew that the government would lose and that the litigant asserting a rights violation would win. So Alan Gura for Dick Heller appears before the Supreme Court and starts speaking the language of strict scrutiny. Justice Scalia starts speaking the language of strict scrutiny from the bench, asking whether Heller wishes the court to embrace strict scrutiny. But Chief Justice Rehnquist puts the brakes on that discourse fairly quickly and expresses skepticism about this tiered scrutiny project, this notion of explaining the entire constitutional universe by ascribing different levels of review to different claims. And typically, tiered scrutiny is subject to the criticism that, well, look at the constitutional text. Where does this come from? Nowhere. There's nothing in the constitutional text that says certain claims trigger rational basis review, certain claims trigger intermediate scrutiny, certain claims trigger strict scrutiny. The Supreme Court made all of this up, arguably beginning in the 1890s when you first see the first hints of the language of rational basis review, and then in the 1940s you begin to see the first hints of the language of strict scrutiny, and then this system starts flourishing in the 1970s, particularly in the equal protection arena. But Chief Justice Roberts says in 2008 he doesn't want to hear this. Let's not talk about strict scrutiny. Justice Kennedy signals also that he may need some convincing to join the opinion that Justice Scalia hopes to write, because Justice Kennedy signals that he wants to overturn that 1939 Miller case. He wants to openly acknowledge that Miller was wrongly decided, that the Second Amendment is not limited to militia-related concerns, that the Second Amendment embraces a right to self-defense. And Justice Kennedy was particularly interested in a right to hunt. At least 5 times during oral argument, he says, but the the framers, the settlers, the colonists, they must have been concerned with the right to hunt. And unfortunately, Justice Kennedy then begins to talk about hunting grizzly bears. And of course, there were no grizzlies in the East, even in the late 18th century. So, that's not necessarily, a logical flaw with his argument. Just, doesn't know about the distribution of different species of bears in the 18th century. But in any case, Justice Kennedy makes clear that he wants to overturn Miller. And Chief Justice Roberts, in 2008, was only 3 years removed from his confirmation hearing, in which he stressed that he wasn't going to become Chief Justice with a view to overturning all sorts of precedent. Many senators pressed him on this point. They asked you, is the New Deal constitutional order safe, or are you going to join the court and lead the court in basically dismantling the constitutional jurisprudence that the late New Deal court and the Warren court and the Burger court assembled from the late 1930s through the 1980s. And Roberts keeps saying, no, I respect a precedent. I'm not some sort of radical. But by 2008, Roberts had developed a skilled capacity to distinguish precedent. So you've got these different factions assembling on the bench in oral argument. In Heller, you've got Justice Scalia and Justice Thomas, who favor strict scrutiny. You've got the Chief Justice, who doesn't want to get involved in tiered scrutiny, and you've got Justice Kennedy, who wants to overturn Miller, and you've got 4 justices who, like Miller, and believe that the Second Amendment has nothing to do with keeping handguns in the home. Justice Scalia writes an opinion, but it's not necessarily the opinion that gun enthusiasts would like. He has to concede quite a bit. He concedes that the right is subject to regulation. The right is subject to long-standing prohibitions on possession by felons and the mentally ill. That prohibitions on carrying weapons in sensitive places like government buildings and schools are presumptively valid. That there is no reason to think that qualifications on commercial sales raise any constitutional issues. That the right is limited to weapons in common use, and that the right does not reach dangerous or unusual weapons. One question that Heller leaves open is, is this a complete set of constitutionally permissible restrictions on gun ownership, or is this an open-ended list of permissible restrictions that could be expanded on a case-by-case basis as future courts confront challenges to entirely different restrictions on gun ownership? Justice Scalia also does not announce any standard of review. The 4 dissenters argue that the original understanding that Justice Scalia describes is historically inaccurate. Justice Scalia relies heavily on dictionaries. He points to definitions, particularly of bearing arms, that for him suggest, and this is his binding constitutional interpretation of the meaning of bearing arms. Bearing arms for Justice Scalia means carrying weapons for purposes of confrontation. The dissenters say the dominant meaning of bearing arms in the late 18th century was doing military service or doing militia duty. Justice Scalia acknowledges that that's one meaning of bearing arms, but he says that's an idiosyncratic meaning. The dissenters point to work by historians And you can replicate this work yourself. You don't have to take the dissenter's view of things. You can go to the Library of Congress website, the American Memory Project, and there are searchable databases of recorded legislative histories in the late 18th century, national and state level. So, the Confederation Congress, the Continental Congresses, the Congress of the United States, and all the state legislatures and colonial legislatures. There's databases of newspapers and pamphlets. There's databases of books in print. And some historians cited by the dissenters report that of the thousands of surviving recorded uses of bearer arms and similar constructs in the late colonial and early national period, at least 95% clearly refer to doing military duty or militia duty. Another argument that figures prominently in Justice Stevens' dissent focuses on specifically the records of the first Congress. So we have no records of debates in the United States Senate until 1794. They were behind closed doors. But you can look at records of the United States House of Representatives for the first Congress. These records are famously incomplete. So if you ever find yourself arguing a case that involves the original meaning of a statute of the first Congress, like, say, the Judiciary Act of 1789, which still figures prominently in the United States Code when it comes to provisions of federal jurisdiction, or, say, the original meaning of the Bill of Rights. One argument that you can make to discount these records of the debates in the House of Representatives is that they're notoriously incomplete. The secretary who kept the records was famously bored. He writes as much in his diary. He doodles a lot. If you look at the original copies, you'll see a lot of sketches of horses. You'll see a lot of spilled ink. He falls asleep and spills the ink well. And he was notoriously a drunkard as well, and was called out for this many times. There were attempts to replace him, but apparently it was a somewhat tedious job, and he had political connections, so he kept the job. But he did record what 12 members of the House said about the draft language, Madison's draft language that became the Second Amendment. And as Justice Stevens stresses, 12 members spoke, or at least 12 members who spoke have some written record of what they said, and it's not verbatim. It's it's a summary. It's bullet points, really. But all 12 discussed militia duty, and most of them discussed a conscientious objector clause that did not make it back out of the Senate. So the House of Representatives sends a version of the Second Amendment with a conscientious objector clause to the Senate. It comes back without the conscientious objector clause. So if you believe in a restrictive interpretation of the Second Amendment, you might want to argue, well, if it's really about hunting or keeping weapons for purposes of self-defense, why is there a conscientious objector clause? That doesn't make sense. You won't very well, you'll argue that the government can't force me to hunt because for religious reasons I'm a vegetarian, because the government wasn't forcing anyone to hunt. The government was forcing people to do militia duty. If you want to argue for an interpretation of the Second Amendment that respects a much broader right to arms, you could say, well, look, that conscientious objector clause didn't make it into the final version. We don't know exactly what happened in the Senate. All we know is the language that goes into the Senate and the language that comes out of the Senate, and there's some record of voting, but there's no record of debates. But we know that conscientious objector clause disappears. Still, Stevens says, look, it's significant that of the 12 members who spoke, not one said anything about hunting or private self-defense. It's significant that 95% of the surviving recorded usages of the phrase bear arms relate to military duty. Justice Scalia makes an interesting move in his opinion. He takes the text of the Second Amendment and labels the militia clause, if you will. I realize, technically, grammatically, it's not necessarily a clause because it can't stand alone in modern English, but the well-regulated militia being necessary to the security of a free state. Justice Scalia takes that language and labels it prefatory. Does this very early on in the opinion. Then he takes the rest of the Second Amendment, the right of the people to keep and bear arms shall not be infringed, and he calls that operational. Cites no authority for this distinction between the prefatory language and the operational language. To some degree, it makes sense. A well-regulated militia being necessary to the security of a free state, well, can't really stand alone in contemporary English usage, at least to our ears today. But apart from that, it's purely hortatory. It expresses a wish. That rather than dependence on a professional army, a standing army, as they called it at the time, that the United States maintain a militia system, something analogous to what Switzerland has today, where the general public serves the state by doing militia duty, as opposed to having a select group of full-time professional soldiers who may not be of the people, who may have a different mentality of the people. But still, Justice Scalia, he is basically outcome determinative, this distinction, and he offers no explanation for it. It's just the labels he attaches. And you know where the opinion's going once that happens. Yeah. Sure. So for historians, not all historians agree, but for many academic historians, as opposed to constitutional law advocates drawing on history, there's this notion called the anti-army trope, or classical republicanism is a label that was popular in graduate school, in history departments in the 70s and 80s. And it goes something like this. The framers, the general public in the late 18th century, were obsessed with ancient history. They were particularly obsessed with Rome, and more particularly still with the collapse of the Roman Republic and the rise of the decadent, debauched Roman Empire. And they like to map this Roman history onto contemporary British history. They said, look back to the 17th century English revolutions. At that time, the people of England were virtuous. They bore their own arms in the service of the Republic in the 1640s or 50s, or during the Glorious Revolution in the 1680s. They didn't depend on a professional army. Certain problems with a professional army that set in as the British Empire expanded in the 18th century and that were associated with the collapse of Rome, reliance on foreign soldiers, mercenaries who were not of the people. The mercenaries had to be paid. That meant taxes had to be levied. The empire became dependent on deficit spending to keep up this military apparatus. And certain members of the legislature developed very close relations, or certain governmental officials developed very close relations with government contractors. That was called corruption. Doesn't mean exactly the same thing as corruption means today. It did have that dimension of taking bribes, but it also referred to people becoming kind of lazy and dependent and not individualistic. George Washington liked to conceptualize himself as the Roman hero Cincinnatus. He was a farmer who was called from the plow to defend the Roman Republic. He was a full-time farmer, part-time soldier. He wasn't a career soldier who took taxpayers' money to lead a life of military affairs. So those who favored the militia made the argument that if the United States is going to be a real republic, survive as a republic, not become corrupt like the 18th century British Empire or corrupt like the Roman Empire, the U.S. will have to rely on a citizen militia in which all able-bodied men are part-time soldiers. They do their military duty. They know how to use weapons. They have the financial means to furnish their own weapons. And when summoned to the defense of the republic, they can do so. This is the understanding that the standard model supplants. A lot of the rhetoric in the 18th century, late 18th century, does focus on this fear of a standing army. A lot of that rhetoric comes out of Massachusetts, where there was a large British garrison to enforce the unpopular tax laws in the late colonial period, the so-called abominable measures, the Boston Port Bill and the Declaratory Act and the Stamp Act and the Tea Act and the Townsend duties. There's a large military garrison that enforced them, and the military garrison wasn't local militia. It was foreign soldiers, whether British or German soldiers or other hirelings in the service of the government. So there was a lot of political thought in the late 18th century that focused on this militia ideal. But the other side of the coin is doing militia duty is kind of a hardship. And by the rise of the Jacksonian era in the 1830s, most states had moved away from the universal militia. People would vote for militia captains who promised, if you elect me your militia captain, we'll never have muster. There'll never be mandatory muster. Vote me in as militia captain, and no one will have to do militia duty. That became a popular way to get elected by the 1820s and the 1830s. There just wasn't that sense of civic duty. People wanted to do other things, make money or go about leading their own lives and not do militia duty on a regular basis. So the system of volunteer militia disintegrates. And for most of American history, there's a small regular army. The peacetime army was never more than 30,000 until the period between the First and the Second World War. And it's really only after the Second World War that the United States maintains a large professional peacetime army. But one question you can't avoid about the Second Amendment is, well, does it matter that the Second Amendment contains this militia clause and was written in an entirely different environment, the different cultural assumptions about what it meant to be in the militia and who was in the militia? We don't depend on the National Guard for national security anymore. The National Guard contributes substantially when called into federal duty, but it's very hard for someone in 2015 to think of the militia in the same terms that the generation that drafted and ratified the Second Amendment did. So anyway, on to McDonald let's see, how are we doing for time, Steve? Can you remind me of when I'm supposed to close down? Steve, step out. Anybody have the schedule in front of them? I've got 30 minutes, okay, because I want to leave a lot of time for conversation with all of you and questions, but we should talk about McDonald and incorporation. So Heller comes out of the District of Columbia. It comes out of a federal enclave. So after Heller, the Second Amendment is alive, it's judicially enforceable, but there's no Supreme Court authority for the proposition that the Second Amendment limits state or local government. For most people living in most jurisdictions in the United States, at least insofar as local legislation was concerned, the constitutional landscape had not changed with Heller. I mean, you could see the writing on the wall, and courts of appeals saw the writing on the wall, but for the most part, they were hesitant. they did not want to jump the gun and beat the Supreme Court to the punch. They lacked the authority to assume that the Supreme Court would overrule those 3 late 19th century cases holding that the Second Amendment didn't apply against the states. That said, there was every reason to believe that the Second Amendment would be applied against the states after Heller. First and foremost, the Second Amendment now had judicial teeth. Unlike prior to Heller, the Second Amendment was judicially enforceable. But equally important, those 3 19th century precedents were all decided at a time when not a single provision of the Bill of Rights had been applied against the states. And by 2008, most provisions of the Bill of Rights had been applied against the states. It was very rare to encounter if you picked up the Bill of Rights in 2008 and looked at all the rights on the list, it'd be very unusual to find a right listed in the Bill of Rights that had not been judicially applied against the states through the Due Process Clause of the 14th Amendment. So as things stood at the time Heller was decided, the Second Amendment hadn't been applied against the states, but it hadn't been applied against the federal government either. Likewise, the Third Amendment, the right against quartering of troops in the home, but that had never been enforced against the federal government judicially. No one assumed that it wasn't a real constitutional right. It's just such a, I suppose, obvious and well-accepted right that it hadn't been abused. Doubtless, you would have a judicial claim. You could get relief if you went home and found soldiers sleeping in your bed, and a bill from the United States, asking you, to put these people up or feed them, what have you. You could get a relief, I have no doubt. In fact, there was one Third Amendment case litigated up in the Second Circuit out of New York. Very strange case. A group of prison guards who normally lived in barracks on site in the prison were not allowed to sleep in their barracks during a prison riot when the governor called out the National Guard and put National Guard troops in the barracks instead. And the prison guards wanted their hotel bill for the time that they were unable to sleep in their barracks in the prison refunded on the grounds that their Third Amendment rights had been violated. But I think the claim was dispensed with on sovereign immunity grounds, so there was no actual decision on the Third Amendment. But I have no doubt that it is a real right. The other rights not applied against the states, and this holds today as much as it did in 2008, are the Fifth Amendment right not to be proceeded against in a criminal matter without a grand jury indictment. The overwhelming majority of state criminal prosecutions are initiated by other means. By an information, by some preliminary hearing in which the defendant is appraised of the nature of the charges, et cetera. But the grand jury indictment is a vehicle that my research assistant informed me. I haven't double-checked the numbers myself, but less than 0.1% of state cases in the United States against criminal defendants are actually initiated by grand jury indictment. And then the Seventh Amendment right to a jury trial in a civil matter where more than $20 is at stake has never been applied against the states either. And I actually helped write an amicus brief in McDonald arguing that Alan Gura, the gung-ho counsel for Otis McDonald, should not get his way on his total incorporation theory. Gura argued that rather than the selective incorporation process by which the Supreme Court had taken individual provisions of the Bill of Rights and made them applicable to the states one by one, beginning with the Takings Clause of the Fifth Amendment in 1897, and then some provisions of the First Amendment in the 1920s, step by step through classic cases such as Mapp versus Ohio, finally reaching the point in the 1970s when everything except the Second, Third, Fifth Amendment grand jury indictment and Seventh Amendment jury trial and civil matters rights have been incorporated against the states. Gura argues the entire Bill of Rights should apply through the Privileges or Immunities Clause of the 14th Amendment. There should be no judicial discretion involved. This entire package of textually committed rights in the Bill of Rights should be put through the Privileges or Immunities portal of the 14th Amendment. That's an avenue that the Supreme Court rejected in the slaughterhouse cases in 1874. The Privileges or Immunities Clause of the 14th Amendment has done very little work since. Gura says Supreme Court history since 1874 is the history of a lie. There's no such thing as substantive due process. Due process means due process. Procedural due process is redundant. The Due Process Clause is concerned with procedural rights associated with fair trial and associated with the ability to make a case in an administrative tribunal with some level of protection, partially analogous to what the defendants have and what civil litigants have in a full-fledged judicial trial. I argued that there's a real practical problem with the Gura approach. Not only would it unsettle 80 years of Supreme Court history or more, covering the incorporation of most provisions of the Bill of Rights through the Due Process Clause. And not only would it call into question the jurisprudence of substantive due process related to unwritten rights, like sexual privacy or the right to marry or the right to bring up children or the right to choose private school or the freedom of association, which there's the freedom to assemble and petition Congress for relief of grievances written into the constitutional text, but the right to assembly that's recognized is much broader. And again, that's done as a function of substantive due process. The court looks at the Due Process Clause and says, well, some rights are so fundamental that no amount of process justifies taking them away. So these substantive rights, like sexual privacy, like access to contraception, like the limited right to abortion, like the right to choose private school, like freedom of association, are constitutionally enforceable rights through the Due Process Clause of the 14th Amendment, or when asserted against the federal government through the Due Process Clause of the Fifth Amendment. Gura wants to take all of this off the table, but the most glaring and potentially seismic consequence of all of this would be to call into question the soundness of every criminal conviction on the state level of persons whose trials had not been initiated by grand jury indictment. So several million prisoners in the state correctional system whose trials followed information or followed some preliminary hearing, but not the grand jury indictment, might very well be able to seek relief if at this late point in the game the court took the total incorporation view and took the entire Bill of Rights, as Justice Hugo Black used to argue, should have been done back in the Reconstruction period, back in Slaughterhouse, and make it applicable jot for jot, dot for dot against the federal government with no unenumerated rights, no substantive due process rights to anything that you won't find written in the constitutional text. Gura did leave that question open. Anyway, Gura's argument appeals only to Justice Thomas. Justice Thomas willing to jettison a century of Supreme Court precedent make the Second Amendment right and every right written into the constitutional text applicable to the states and local government through the Privileges or Immunities Clause of the 14th Amendment. But Justice Alito assembles the four-justice plurality. The Thomas vote is necessary to bring up the 5 required to make the Second Amendment applicable to the states, but the Alito plurality takes the view that substantive due process is the appropriate vehicle to apply the Second Amendment rights to the states. Otis McDonald, very sympathetic, a plaintiff, elderly man in a high-crime neighborhood who had suffered several break-ins, I believe had been threatened on the streets as well, recognized to have a constitutional right to self-defense, right to have weapons in the home for purposes of that constitutional right to self-defense. Justice Alito says the Second Amendment right applies to the federal government precisely the same way it applies to the states. He embraces Justice Scalia's list of presumptively valid regulations from Heller, embraces Justice Scalia's formulation that the right is essentially the right to carry weapons for purposes of armed confrontation, but that it's an especially important right in the home. So as far as Supreme Court jurisprudence goes, not many questions are answered as of today. All we know is that the Second Amendment protects against both state and federal abuse a right to have weapons that are commonly held, more specifically the right to have a handgun in the home, operational condition, readily accessible, not locked, not unloaded, for purposes of self-defense. You can think of hundreds of open questions. Weapons outside the home, restrictions on the number of weapons a person can own, requirements for licensing, registration, mandatory training, taxation. All of these questions open. 2 potential avenues towards a third Supreme Court case. One of them discussed in the beginning. Judge Easterbrook, writing in the 7th Circuit last summer, upheld the city of Oak Park, Illinois' ban on so-called assault weapons, ban on certain high-capacity magazines. He didn't apply strict scrutiny, didn't apply intermediate scrutiny, didn't apply rational basis review, simply concluded that the right to defense of the home can effectively be preserved with weapons that Oak Park did not ban, like handguns with a smaller magazine. Just yesterday, Judge Traxel of Greenville, Chief Judge for the 4th Circuit, doesn't strike down the Maryland law, but reverses the federal district court opinion upholding Maryland's similar ban on so-called assault weapons, or weapons with larger magazines. Remands to the federal district court for application of strict scrutiny. So we now have interesting regime in place in the 4th Circuit. Not that your gun rights are at risk in the 4th Circuit, because legislatures in the 4th Circuit are inclined to respect the people of the 4th Circuit's wishes, at least outside of Maryland and suburban Virginia, and some urban jurisdictions, to have access to weapons with little in the way of regulation. Another potential split in the circuits involves the dispute between the 7 jurisdictions that are may-issue states and the vast majority of jurisdictions that are must-issue states. So in some jurisdictions, when a person applies for a license to have a weapon, the issuing of that license depends upon a discretionary determination by an official, requirement that the individual seeking the license shows some particularized need beyond just general self-defense, fear of crime, we live in dangerous times, etc. D.C. is a may-issue regime. It appeared very likely that the D.C. Circuit would uphold a federal district court's decision that may-issue regime was unconstitutional and violated the Second Amendment, but the panel had to dismiss the claim on jurisdictional grounds. The district court that heard the case involved a decision by a judge serving by designation from another district whose designation did not reach that particular case. The names of the litigants had changed after the appointment. There is a decision out of the Ninth Circuit now pending for review in the en banc Ninth Circuit, also holding in a decision by Judge O'Scanlan that the may-issue regime violates the Second Amendment right, and also enforcing that right by application of strict scrutiny. The really bizarre thing, and this is a note I'll leave you on, about this may-issue, must-issue dispute focuses on the notion of what weapons restrictions were widely deemed constitutionally permissible in 1868 when the 14th Amendment was ratified. And for some reason, the debate in the courts, well, the reason is the litigants have pushed this issue, turns on the meaning of the Statute of Northampton of England of 1328, about 2 decades before anybody in Europe had firearms, which prohibits carrying weapons at fairs, but has a clause that says the weapons are prohibited to the extent that in Latin they put the people in terrorem, that they cause terror among the people. Those who favor a restrictive meaning of the Second Amendment say, well, look, this was just pleading. It's throwaway language. It doesn't mean anything. All weapons were presumed to promote terror. Defenders of access to handguns argue, well, everybody was familiar with the Statute of Northampton of 1328 in 1868 when the 14th Amendment made the Second Amendment applicable to the states, but everybody assumed that it reached only odd weapons or terrifying people who were likely to put the general public in fear when they appeared armed in public, so it doesn't reach regular people with common weapons. Strange debate, I think. The question of whether regulations are permissible today depends on the meaning of an English statute of 1328 before guns even existed outside of China. Very, very strange debate in my view. But the floor is yours. Great point. Right. So that's a common argument, and I think an effective one that's made in the Second Amendment litigation arena. Why would you expect to see things in the debates that were too obvious to mention? Like, firearms are useful for self-defense and firearms are useful for hunting. There was a debate, about 12 or 15 years ago now, about how widespread firearms really were at the time the Second Amendment was ratified. And a historian named Michael Belials wrote a Bancroft Prize-winning and Pulitzer Prize-winning book arguing that weapons weren't actually very common. Firearms weren't actually that common in the late colonial or early national period, and he relied heavily on probate records, inventories of decedents' estates that he said showed that relatively few people had guns. Turned out this guy Belials was a pathological liar, and he made up probate inventories. He's an interesting guy. The first time I met him, he told me about his 3 kids. The second time I met him, he told me about his 1 kid. And I assumed there'd been no intervening tragedy. I assumed that he had been disowned by his own children when he became a controversial figure. because he described the children as quite young. But for a long time he claimed his records of these probate inventories had been destroyed when the sprinkler system at Emory, where he worked, had there'd been a false alarm. The sprinkler system engaged, and his yellow pads with his notes became drenched, and he could no longer recover his records. But building maintenance had no record of this sprinkler mishap. So eventually Belleals was discredited and had to forfeit his prizes and give up his position. But Belleals actually may have been on to something. If you discount the probate inventories and you look at something called the Federal Militia Census, which began in 1802 and then was conducted again in 1806, and then every decade from 1810 until about 1850, when the militia system had largely disappeared, it was quite counterintuitive. So of all people, President Jefferson signs off on this, which involves state officials, so it is completely inconsistent with Prince and the anti-commandeering rationale, involves state officials under orders of the state adjutant general that originated with the President of the United States, going door to door, knocking on every door, saying how many militia-eligible people live here and what weapons do they have, and may we see the weapons and inspect them for conformity with the Militia Act of 1798. And those censuses show that about 40% of the population was armed. But the bigger question for me is, who cares? What difference does it make, or explain to me what difference it makes whether 10% of the population or 100% of the population was armed? The best version of the explanation as to why this debate is significant that I've heard comes from a young historian, Robert Churchill, and it goes like this. Guns were widely distributed. People became familiar with guns. They took for granted that they would have guns because guns were widely distributed. Because they took for granted that they would have guns, they resented any regulations that might have interfered with their liberty to use guns, and they certainly resented any measures designed to confiscate their guns. This resentment of interference with a common practice began to take the form of rights talk, to use a phrase popular with some law school academics. And you can picture a parallel development in contemporary America. There's no constitutional right to have a car as such, but cars are widely distributed. People take for granted that they may have cars. If suddenly the government developed an interest in very heavy regulation, confiscation, maybe an environmental regulation that limited each family to one car that got at least 40 miles per gallon, you would hear rights talk. And the rights talk related to guns, Churchill argues, was sufficiently robust by the 1780s that it finds its way into the Second Amendment. So I think that's the sense in which this debate about whether guns were widely distributed matters for constitutional purposes. I think that the reason people who are skeptical of the Second Amendment right to arms make the claim that guns weren't widely distributed is that they want to suggest that guns aren't at the very core of American history the way that many gun enthusiasts argue that they are. And that taps into Justice Alito's specific formula for a substantive due process as well. In McDonald, Justice Alito says, well, the following rights are judicially enforceable. The following rights are fundamental. What rights are fundamental? If they are fundamental to the American system of ordered liberty, or they are deeply rooted in American history and tradition. So if guns are deeply rooted in American history and tradition, according to Justice Alito and McDonald, the right to have guns is part of substantive due process and should be constitutionally protected. If they're not deeply rooted in American history and tradition, if this guy Belleals was right and very few people had guns, then perhaps the Alito test is not satisfied. And by the way, if a right's fundamental for Justice Alito, what does that mean? It just means it's judicially enforceable. A lot of opinions in the 70s and 80s, as recently as 1997 in Glucksberg, a right to die case in which Chief Justice Rehnquist wrote that there may be a right to die, but there's no right under the Constitution to physician-assisted suicide. States may continue to criminalize physician-assisted suicide. As recently as 1997, Chief Justice Rehnquist says when a right's fundamental, that triggers strict scrutiny. Justice Alito doesn't say it, so the question is open, and hence the split in the circuits today. We've got the Fourth Circuit saying Second Amendment right under Heller is fundamental. What does that mean? Strict scrutiny must apply. Supreme Court hasn't said so. And then Judge Easterbrook for the Seventh Circuit out of Oak Park, Illinois, saying, okay, the right's fundamental. What does that mean? It's judicially enforceable sometimes, but the right to self-defense, fundamental though it may be, is not undermined by a ban on so-called assault weapons. Sure. So that's an argument as well, and there's a lot of capital to be made by drawing a parallel between the Second Amendment in the U.S. Bill of Rights of 1689 and language about arms in the English Bill of Rights of 1689. And those who favor a restrictive interpretation say, well, if the U.S. Bill of Rights is just rephrasing the English Bill of Rights version of the right to arms, that right textually in 1689 is limited by law. That's what the text says. It's limited by law. It's a right for Protestants only, and it's, quote, suitable to their conditions. So that's a right that doesn't contemplate a right to hunt. Now, there's some interesting, they're not necessarily ubiquitous in the U.S., but there is some debate about whether the right to hunt in the late 18th century allows people to enter other persons' lands. But there wasn't, a system of park rangers and an anti-poaching regime in the U.S. the way there was in Europe. But I don't think it was the norm, say, in 1785, if somebody came onto your land to hunt, that you had to tolerate them. You could, ask them to leave. And Jefferson describes a right to hunt in his draft of a Virginia Constitution in 1783. It's an appendix to his notes on Virginia. He describes the right to hunt on private lands, but what he means is a right for people to hunt on their own private lands or hunt on other people's private lands with permission, not a right to go hunt on your neighbor's land without permission.
Well, Professor, thank you. That was, again, that was great.
Well, thanks. Thanks very much for having me. And as soon as I digest that 90-page opinion, hot off the press from yesterday afternoon, Fourth Circuit, right? This is not some abstraction. This is our law. Not just about Maryland, it's about South Carolina too. So I'll send that to Steve, and he'll distribute it to you. And thanks for having me.
Thank you, Professor. I'll take your mic and
I'm gonna pass it on.
Yeah, pass it on. I got your hands full.